Hey, this is Attorney Drew Page. Welcome to the Drew Page channel. In this video, we are going to talk about the motion for mistrial that Amber Heard's attorneys have filed on her behalf in the Depp versus Heard defamation case. If you found this video helpful, please take just a quick second, subscribe to the channel. Thank you so much to those of you who have subscribed. I really appreciate it. Also, if you will, like this video so that it'll pick up by Google and by YouTube, and we'll get out to more people. And hit the notification bell so you don't miss any of these videos that pop up. So with all that being said, the attorneys for Amber Heard have filed a motion for a mistrial. And the reason for this motion is because they discovered that a juror was placed on the jury who was never summoned. In fact, what happened was, according to the news reports in regard to this motion, the person who was summoned was a family or household member of the person who was actually supposed to be in the jury trial, had the same last name, lived in the same household, but they were clearly not the same person. They had a significant age difference and were clearly not the same person. However, the issue regarding this particular juror, from my understanding, is that this was not discovered until after the fact. That's how the news reports are coming across. And so the question is does Amber Heard have a case here of being able to set aside the verdict that Johnny Depp got against Amber Heard? And what does this teach us about mistrials altogether? Well, since this is a case that's being heard in Virginia, we would need to look at the law in Virginia. So any case where you've got something pending, you've got a legal question, the first place you want to look is in the law of that particular jurisdiction. So in this case, it would be Virginia. And when you figure out where you're supposed to do your research, then you need to know the steps. And the first step would be the Constitution, which is not at issue here. Then after that, you look at the statutes. And there is a specific statute on point that deals with this particular question, and that is Virginia Code Section 8.01-352. And in that code section, it says in subsection A, prior to the jury being sworn, the following objections may be made without leave of court. In other words, without permission of the court. They don't have to seek permission. They can just make an objection prior to the jury being sworn. An objection specifically pointing out the irregularity in any list or lists of jurors made by the clerk from names drawn from the jury box, or in the drawing, summoning, returning, or impaneling of jurors, or in copying or signing or failing to sign the list. And 2, an objection to any juror on account of any legal disability after the jury is sworn. Such objection shall be made only with leave of court. So prior to the impaneling of the jury, you don't have to seek permission of the court to make an objection. But once the jury has been sworn in, you have to seek permission from the court in order to make the objection. Clearly, in this particular case, this would be a post-jury impaneling motion. It is a motion to set aside, so it's obviously after the jury has made its decision, after it's been impaneled. So the court has to first be willing to hear the objection. They may not even allow this to be heard. They may just outright deny the request for the motion to set aside on that particular issue. But they may also decide, well, we will allow you to make your objection to preserve that issue for appeal, which is probably what the defense attorneys are trying to do anyway. In subsection B, it gives a little bit more detail about the situation at hand. It says, unless objection to such irregularity or disability is made pursuant to subsection A herein, and unless it appears that the irregularity was intentional, or that the irregularity or disability be such as to probably cause injustice in a criminal case to the Commonwealth or to the accused, and in a civil case to the party making the objection, or in this case, the defendant Heard, then such irregularity or disability shall not be cause for summoning a new panel or juror, or for setting aside a verdict, or granting a new trial. So that's the key language in 801-352 that I think would apply here. And there's a couple cases on point. Hill versus Berry was a case where after the jury was impaneled, there was some argument under a Batson challenge that African Americans were wrongly excluded from the jury panel through the use of peremptory challenges. But because the counsel waited until after the jury was impaneled, they had to have leave of court to make the objection, and the court granted his request to make that objection. So therefore, it was deemed not to be waived, and so then they had to go through the analysis of whether that particular misuse of peremptory challenges had created some form of injustice in the case. So that was one case. There was another case where a convicted felon was able to find his way onto the jury panel, and there was objection made after the verdict had been rendered. There was some post-verdict discovery that was found that showed that these two jurors were convicted felons and should not have been on the jury to begin with. But the court said because it was made after the fact and the trial court did not grant leave to make the objection, that the objection had been waived. So what does that tell us about mistrials in general? Number one, if you find that there's something wrong that happens in the trial, okay, you need to preserve that issue immediately. And this is particularly true when it comes to evidentiary things, which are a different topic of discussion. But here with jury aspects, you need to make those objections as soon as you find them. And here's the thing is that it even notes that in this statute that there may be irregularities, there may be problems, things happen. But if you can't show that there's been some sort of injustice, you can't show that there is some prejudice that's resulted from these irregularities, then you're probably out of luck. The issue is those types of things should be found at the beginning of the trial. When they're going through the list of names of people who are summoned, and there's lists that are generally given at least a few days before trial to all of the counsel, and they have a responsibility to use due diligence to go through the list and see who is on the jury panel. And if someone shows up and is not the right person, that's on the attorneys and the trial judge at the time to discover those things. And if you don't raise those objections, generally they're waived. Now, again, this particular code section allows the trial court to grant permission or leave of court for someone to fix those things after the jury has been impaneled. So is it possible that Amber Heard can persuade the judge that this should be overturned? Well, the first step is they have to show, they have to get permission, they have to get leave of court to make the objection on the motion to mistrial. If the trial court doesn't even grant that opportunity, it's done. And they can appeal all they want, but it's a post-impaneling objection. So if they don't have leave of court, they're screwed most likely. But let's say the judge does allow that objection to be made. Well, again, that doesn't necessarily mean that the judge is going to see things their way, because then they also still have to show that as a result of this mistake, that there was some sort of prejudice that occurred. And from what I'm seeing in news articles, it's just basically that they're arguing that even the court should agree that, justice isn't served when you summon the wrong person. And, but that's just a general prejudice. That's not a prejudice that's specific to Miss Heard. So I think that she has a really tough hill to climb here in getting the verdict overturned on this basis. Perhaps there are other bases, or perhaps there's more to the story than what the media is letting on. I'll keep my eye on this, because these type of evidentiary objection things are things that excite me, having been a trial practice professor, loving the rules of evidence, and being a trial lawyer myself. These types of things really are interesting to me, and I hope they are to you. So the big takeaway here is, if you're ever in a trial, make sure that you preserve your objections immediately as soon as something wrong happens. The longer you wait, the more likely the courts are going to see it as being waived. So we'll see how the Heard Depp case handles this particular situation. It should be fun. So I hope you found this video helpful. Please subscribe to the channel, like the video, hit the notification bell, and until next time, stay tuned.